A very good day to all our listeners. I hope you are all doing well. UCS is back with another interesting podcast topic. Can a POSH case be reopened and reinvestigated by the IC? In discussion, we have with us Anupamavi, our chief trainer from UCS, who is a lawyer with 20 plus years of experience with specialization in labor law, general corporate laws, is a director on the board of several companies, and who also has a postgraduate diploma in industrial psychology. Hi Anupama.
Hi Kaveri, good morning.
Anupama, under POSH, I know that one can appeal against the recommendation given by the IC in a court or tribunal. However, I have a very unusual question for you. Can the same case be reopened for investigation by the IC? In other words, what I want to ask you is, if in a case of sexual harassment, the punishment has already been awarded by the employer to the respondent or the complainant, depending on the case, can the same complaint be reopened after passage of time? If yes, what are the circumstances under which it can? Is there a timeline? In law, there's always a grey area, and I do believe that with your expertise, you can definitely clear my doubt.
Thank you, Kaveri. Very interesting question indeed. In fact, I came across a similar situation a couple of years ago when a lady complained against her boss. Apparently, it was an act of sexual harassment which happened at a car parking where no one was present, and she complained to the internal committee. However, which seems to be the case in most of the time that I have come across, the minute such a case was received, the head HR, who was a man and who was not exactly a part of the internal committee, and the employer immediately got involved because they thought, oh my god, it's a case of sexual harassment, how can this happen? And they had a discussion with both the complainant as well as alleged perpetuator. And after the discussion they had, they just randomly gave him a warning letter and he immediately apologized. Now, the funny part is, within a few months of something like this happening, the respondent or the perpetuator came back and said what they had done was unfair, he was under duress and they should not have done this, and he was very unhappy with what happened. Now, the company came back to me when this letter came asking me my opinion, and that's when we realized that though there was an internal committee, no investigation was carried out. Though there was an external counsel, she was never involved, and they actually did not even have an idea about who the person was. This being the situation, we had the employer talk to the respondent, who had expressed his concern that his family was disappointed with what has happened and they wanted this to be relooked. Once we received this request, then we went back to the complainant and asked her if she was willing to reopen the complaint. She was also quite okay with it. And then we made the respondent write a letter to the management, including to the internal committee. Subsequently, basis that letter, we sent a letter to the complainant. The complainant also agreed to it. And then we carried out an inquiry. Though the inquiry did come out that he did commit an act of sexual harassment and the punishment was given, we had to go a little lenient on the punishment only because the employer had not followed the right process and he was already punished. So this, and of course we had to make them withdraw the earlier apology letter as well as the warning letter. Now, to answer your question in a very simple way, yes, we can reinvestigate a case. However, the most important factor in such a reinvestigation is both should agree to it. As you rightly pointed out, the relief to any person at that point in time is an appeal. They can, of course, had this man gone in an appeal, the case would have not only been struck down, the punishment would not only have been struck down, the employer would have been made to pay a compensation as well. But in this case, they both agreed to reopen the case and have it investigated because I guess in many ways a solution within the organization is much better than approaching the courts, which may be a long drawn process. So if both of them agree and process was not followed, then yes, it can be reopened.
Anupama, it was very nice to know that a case can be reopened, but I also heard you mentioning certain ifs and buts. So, what are those circumstances when a case cannot be reopened?
Yes, Kaveri, you're right. It's not like every case can be looked into it again and again. So what had happened in the previous case that I just cited for you was the inquiry was never conducted by the internal committee of the company. And therefore, there was an opportunity to resend the case to the internal committee, have them examine it, and then come to the conclusion. Technically, it was not a re-examination for the internal, it was coming before it for the first time. In such circumstances, cases can be reopened. However, if there has been a complaint before the internal committee has sat over it, given an award basis which an employer has taken some action, in such cases, the cases cannot be reopened, and the only possibility is for it to go to the court. Yes, in case of principles of natural justice, if there is some error in the way the award was written and there are some clarifications, you can have a review if possible, but definitely in such cases, the cases cannot be reopened.
Thank you, Anupama. To many organizations, if they face such situations where requests are made to reopen and reinvestigate case, what are your suggestions?
As I said, nothing is standardized here. So if there is a situation where a request is made for reopening the case, the employer can only direct it to the internal committee, and the internal committee, if it's completely satisfied that the matter had come to its attention and it had followed all due process, the request for re-investigation can be rejected. However, if it comes to the internal committee, just like the way I spoke to you about a case a few minutes ago, in such a case, yes, the internal committee may investigate into it because it had not come before it earlier, subject, however, to both the complainant and the respondent on their own free will and accord agreeing to such investigation once again.
Thank you, Anupama, for this very informative session. And listeners, I hope you've learned a lot from this. Ladies and gentlemen, do get in touch with us with your queries, suggestions, and feedback by emailing us at admin, @upseedconsulting.com, or writing to us on LinkedIn, Twitter, Instagram, or Facebook. We will be back again soon with another interesting topic. Until then, wishing you all a great day.